Now, hi, my name is Richard Epstein, and along with Mario Rizzo, we're the co-directors of the Classical Liberal Institute. And one of the offshoots of our particular situation is a program which we call TIP, which is the Technology, Innovation, and Intellectual Property, which are headed very much by Adam Mossoff and Bo Heiden. And today what we're doing is putting together a program that relates to that work, which deals with a problem which is both shockwaves of pleasure on the one hand and fear on the other through the entire IP community, which is the question of what sort of waivers, if any, should be given in connection with vaccines and other products as an outgrowth of the COVID situation. I'm going to participate in this as an interested observer. The moderator is going to be our own Liya Palagashvili, and I will turn it over to her because I think that she will be able to set the framework, tell us something about the format, and then we will go right into the presentation. So I'm going to put myself into the background. Liya, it's all yours.
Good afternoon, everyone. And my name is Liya Palagashvili, and I'm a senior research fellow at the Mercatus Center at George Mason University, and also a fellow with the Classical Liberal Institute here at New York University School of Law. So thank you all for taking the time to join us today for a pressing discussion that has a global reach. The United States has recently announced its support for a petition at the World Trade Organization that would waive all intellectual property rights on drugs, vaccines, or other responses to the COVID-19 pandemic. But what does that actually entail? And is it a good thing? Will it mean a faster end to the pandemic for many countries around the world that are still experiencing the height of COVID, such as India and Brazil, for example? And will this IP waiver have significant implications for future innovations? It turns out the IP waiver has sparked quite a debate, and we'd love to take the opportunity here today to have a discussion of these issues. Before we jump into the content of today's discussion, I'd like to take a moment to review some housekeeping items. We will have 30 to 35 minutes of Q&A at the end of the session. And I'd ask all of you to submit your questions throughout the entire discussion. You know, if one panelist has something that sparks a question, you can send it in right away by typing it into the Q&A box. I will try my best to get to every question, and our intention is to have an engaging conversation, so your participation will be key in achieving that. And now I'll take a moment to introduce our expert panel here today. So maybe I'll have each of them wave their hands when I introduce them. But first, we have Sharon Sandeen, who is the Robbins Kaplan LLP Distinguished Professor in IP Law and the Director of the IP Institute at Mitchell Hamlin. Professor Sandeen is also an internationally recognized scholar on trade secret law and has written 3 books and more than 24 articles and book chapters on this topic, including writing the first case book on trade secret law in the United States. And prior to becoming a professor, she practiced law for more than 15 years and was also an IP litigator and an intellectual property specialist. We also have here today Josh Sarnoff. He's professor of law at DePaul University. Professor Sarnoff is an internationally recognized expert on the intersections of intellectual property law, health law, and international law. So quite perfect for the discussion here today, as it's on all 3 of those intersections. He has previously testified before the Intellectual Property Subcommittee of the Senate Judiciary Committee, and he has previously served as the Thomas A. Edison Distinguished Scholar at the U.S. Patent and Trademark Office. We also have Dr. Bowman Heiden. He's the co-director of the Center for Intellectual Property, as well as the co-chair of the Technology, Innovation, and Intellectual Property Program here at the Classical Liberal Institute. Dr. Heiden is also a visiting professor at UC Berkeley and a member of the European Commission High-Level Expert Group on Standard Essential Patents. Dr. Heiden's research is at the interdisciplinary interface of economics, law, and innovation, and in particular on intellectual property and open innovation in knowledge-intensive sectors. And finally, we have Adam Mossoff. He is a professor of law at the Scalia Law School at George Mason University, and he is the co-chair of the Technology, Innovation, and Intellectual Property Program at the Classical Liberal Institute. Professor Mossoff's expertise is in intellectual property and his scholarship has been relied on by the US Supreme Court, by the Court of Appeals for the Federal Circuit, and by federal agencies. And he has been invited several times to testify before the US Senate and the House of Representatives on intellectual property legislation. I wanted to take a moment to give some quick background information on what we're talking about today, because it can be a little bit unclear what exactly the IP waiver is and how this will get managed on the international stage. And after I give this brief background information, I'll have each of our panelists begin with their opening remarks. So first and foremost, the discussion here today is about an intellectual property waiver, not only a patent waiver. An intellectual property waiver means it's far beyond just sharing of patents. It also means we're talking about transferring trade secrets, the know-how, and potentially therapeutics, diagnostics, medical devices, and perhaps other broader forms of technical assistance. Second, the IP waiver is taking place through the World Trade Organization, or the WTO. 26 years ago, the World Trade Organization adopted an agreement called the Trade-Related Aspects of Intellectual Property Rights, which is called TRIPS for short. So we'll be referring to that as TRIPS. What TRIPS did is set a minimum standard of IP protection that must be provided by all 106 countries who are members of the WTO in areas such as copyright protection, trademarks, industrial designs, patents, and trade secrets. It also set procedures for what enforcement, administration, and dispute settlement of IP rights would look like. One of the main intentions or stated benefits of such an agreement was that it would accelerate investment and technology flows to different countries around the world, especially into developing countries. The idea is that prior to TRIPS, global companies may not want to set up offices, plants, or labs because some countries lack laws that would protect against IP theft. So by requiring a minimum standard for all member countries, TRIPS could effectively mitigate IP theft concerns and encourage promotion of technology flows and greater foreign direct investment. The IP waiver for COVID that we're talking about today is with regards to waiving these requirements within that TRIPS agreement. The proposal emerged in October of 2020 when India and South Africa asked the TRIPS Council to waive within the agreement such IP protections related to responses to COVID-19. The proposal only gained momentum in April when the United States said it would support such an IP waiver, and hence why there is an active debate about it right now. One more thing to clarify. So within the TRIPS agreement, there is a provision called Article 31 for compulsory licensing, which effectively provides an exception to countries for obtaining a license for a patent in case of a national emergency or other circumstances of extreme urgency. And effectively, if Article 31 is invoked, it would remove a W2 member country from its general obligation to recognize exclusive patent rights. Article 31 has been discussed in the context of the COVID-19 vaccines, because if invoked, it could grant specific countries an exception for protecting vaccine patent rights. However, Article 31 only covers patents. It does not cover other aspects of intellectual property that we are talking about today, such as trade secrets, technical know-how, and so on. Therefore, our discussion here today and the debate about the IP waiver in general extends beyond the Article 31 provision, since the IP waiver entails many different aspects of intellectual property, and Article 31 only applies to patents. So to sum that up, because it can be a little complex, unlike with past proposals for patent waivers at the WTO that were ultimately implemented through this Article 31, the IP waiver currently under consideration by the WTO and now being negotiated by the member countries would waive the obligations and international enforcement mechanisms set into place by TRIPS. So with that background to set the stage of our discussion, I'll now turn it over to our expert panelists to each provide opening statements on the IP waiver at the WTO. And we'll start first with Sharon.
Hi, thank you very much for inviting me to participate in this very important debate. Before I start my comments, I want to make one clarification. The draft of the waiver, the May 21st draft in particular, doesn't call for an all-out waiver of IP rights. It's for a limited time, 3 years. So that's, I think, an important clarification concerning this debate. Now, given the global COVID-19 pandemic, it is obviously a very important debate, but sadly, it should not take a global pandemic to highlight the issues that we will be discussing today. In this regard, I first want to put the debate in context, and obviously in the context that I think is important. For me, there are two separate issues. One, of course, are the terms of any TRIPS waiver and whether it will accomplish what we need to accomplish to address the COVID-19 pandemic, which I'm sure, as Josh will comment on, has a lot to do with the manufacture and distribution of life-saving vaccines and other inventions. Even those who favor robust exercise of the flexibilities in TRIPS think that the waiver, as worded in the May 21st draft, is much ado about nothing. And one reason this is so is because nothing much will change as a result. The developed world, now referred to as high-income countries, including the US, will not suddenly stop enforcing IP rights. And low and middle-income countries already have the ability to exercise flexibilities that are built into TRIPS. Article 31, including the one and only amendment to TRIPS since its adoption, the Article 31Bs, already provide a lot of flexibilities. But I also want to note two other provisions that are in the TRIPS agreement. One is Article 7 that states that the protection of IPR should contribute to the promotion of technological innovation and the transfer and dissemination of technology to the mutual advantage of producers and users of technological knowledge, and in a manner conducive to social and economic welfare and a balance of rights and obligations. And Article 8 also provides that countries can adopt measures necessary to promote the public interest. So this leads me to the second issue that the COVID pandemic has served to highlight, and to me is really the crux of the problem. The real problem is too much information and knowledge is being locked down and restricted, not only in ways that hamper the production of life-saving pharmaceuticals and access to medicines, but also in ways that hamper, ironically, innovation and creativity, and which restrict competition. Now, I know that others in this panel are more experts on John Locke's writing than mine, but when I read it, I don't see just what he wrote about property rights. What I see is what he wrote about reason and knowledge acquisition and knowledge diffusion. And I can't find anything in his writings to suggest that he would apply a property view to restrict the diffusion of information. Thus, I find it ironic that in this day and age, what I might characterize as the incessant clamoring for property rights and information is actually leading to restrictions on information knowledge diffusion, and therefore is leading to a reduction in reason, innovation, and creativity. Perhaps this was not planned and is an unintended consequence of the assertion of property rights in information, but the incessant and incremental efforts to restrict information knowledge access are unmistakable. The COVID-19 pandemic highlights the need for the international community to think more deeply and carefully about the value of information flows and access to information, including the role that these principles historically have played and should play to limit the scope of IP protection. I believe that our mutual interests in public health and in competition demand that we explore these issues carefully and deeply. Thank you.
First, let me thank CLI and particularly Adam, who's an old friend, and Bo for inviting me to participate, and also for Sharon, for another old friend, for giving me the opportunity to plug my article on Locke's discussion of the spoliation and waste provisos and why, therefore, we shouldn't have intellectual property in discoveries of nature. It's in the Hastings Law Journal for anyone who cares. Obviously, this topic is critically important to the world, but it's not going to be limited to this pandemic, nor is it going to be limited to pandemics. The basic question of why we have a waiver is because of the failure of voluntary measures. Particularly, the World Health Organization tried to set up a cooperative facility called COVAX and a patent pooling facility called the ACT Accelerator. And the biopharma industry basically just said, no, we're not going to voluntarily license or give away our intellectual property for the world to gear up quickly for production. I'm going to read to you from an article from Politico from May 14th, 2021, captioned "Big Vaccine Makers Reject Offers to Help Produce More Jabs." Quote, BioLice in Canada, Incepta in Bangladesh, Teva in Israel, Bavarian Nordic in Denmark have all asked to assist in the manufacture of vaccines. As yet, none is a deal. Yet recent history shows numerous examples of industry turning down offers of help from other drug makers, citing the complexity of the process, safety concerns, and a lack of time to carry out technology transfer. As most of you know, given the Delta variant and also the low levels of vaccination in most of the world, this pandemic isn't going away. And we also have nowhere near the capacity in vaccines to address the issues that we need. However, this waiver is not just about vaccines. It's also about therapeutics, of which we have relatively few. Merck Molnupiravir is an antiviral pill, which will soon be coming to a decision on FDA clinical approval. And that pill is clearly going to be able to be manufactured around the world without the transfer of know-how. Because we're very good at small chemistry manufacturing. We've done it for years. That's why we have a big pharmaceutical generics industry. There, the patent waiver, to the extent that it's patent specific, is going to be very important. But more importantly, the vaccine context, unlike the therapeutics, also is going to require patents as inputs to manufacturing. The most important thing, though, about the waiver, again, is first, it's not self-executing. Countries have to adopt measures to do the things that are currently in their law that would prohibit them from acting. And quite frankly, again, Article 31 actually provides no substantive grounds to restrict the grant of compulsory licenses by countries. Instead, it only says that countries don't have to negotiate with rights holders in the case of an emergency, of which I would think a pandemic easily qualifies. So what is going to be needed, even for vaccine manufacture, is first, the waiver of any number of patent rights as inputs to research, inputs to clinical approvals, and inputs to manufacturing in order to scale up to the levels that we clearly are going to need. I'll note in this context that Pfizer has been alleged to have made its vaccine and gotten approval for it using Allele's M-neon green technology. It's probably immune from lawsuit for patent infringement because of something called the Bolar Amendment, where after a federal circuit case, our Congress said, we don't want patents to interfere with clinical trial development of information, further to Sharon's point about not locking up information or technology. And there, Pfizer is claiming that these patents are in interference with its development and are, a burden on the patent system, and they should be free to use that technology without any payment. Precisely what the waiver's premise is, we need to do this to much more rapidly scale up. So where does this leave us? It leaves us in a situation where, particularly for therapeutics, for other forms of PPE, medical diagnostics, such as ventilators, all sorts of stuff where we have the capacity without know-how transfer to gear up manufacturing. The waiver authorizes states to not implement the TRIPS requirements. It's all it does. Perhaps in some states it will be self-executing, but in most cases it won't. So there, the states simply have to take action to authorize for patents through compulsory licenses or other measures, or through for other rights, particularly trade secrets and know-how, which for vaccines is at least a significant rate limiting step, to force the transfers of that knowledge in order to be able to gear up production to save the world. Again, voluntary licensing has been wholly inadequate here, and the pharmaceutical companies have made it substantially worse by refusing to license companies that had the capacity to gear up our vaccine manufacturing much earlier. They have not been forthcoming in regard to transferring other technologies through the ACT accelerator, and they could have done so and could have done so on commercial terms. So at the end, this isn't just about improving our world health situation. It's about the greed of the companies to refuse to transfer the technology that the world needs. One last piece, just because I'm a history buff as is Adam, you have to go back to the original understanding of patents of importation and working requirements. The idea of granting patents in many cases was to import technology so your own country could come up to speed in the world and produce the products. We went from there to a disclosure model where the disclosure itself would have authorized everybody to make and use, rather than having 2 lifetimes of, I forget the name of the word, but inductees who were going to be trained in the technology. That was how we got 14 years, 2 times 7. And the make and use disclosure would have been sufficient to make anybody able to make the patented invention around the world. Conversely, here, as law has developed, the disclosures are not adequate precisely because many of the pieces of information are trade secrets and know-how. There is a power to be able to compel those know-how transfers and to compensate for any losses of value or losses of the trade secret if it's even necessary to do so. But countries need to get past their nationalism to get there. So really what this is about is it's about trade disputes and nationalism, and the world needs to get past that. And with that, I'll turn it over to Bo.
All right. Thank you very much. Thanks. And very nice to be here today. Thank you, Sharon, and thank you, Josh, for starting us off. I'm going to put on 3 hats for my little introduction here, since I tend to work interdisciplinarily these days. So the first one would be my engineering hat, since I started out as an engineer. And when there was when the virus was known to became a pandemic, and when we knew we needed to get a vaccine, the basic engineering question was, how can we safely and quickly develop and distribute a vaccine for COVID-19? That was the question, right? And what's interesting is that by the end of 2021, the current forecasts are that we will have between 9 and 12 billion vaccine doses that will be made available, enough for global herd immunity. Now, it's possible that we won't reach that, but those are the different forecasts that are now today. And when I go back and I was reading the press from the spring of 2020, this is just nothing short of amazing. So the hypothesis in the best case that no one thought could happen would be August of 2021, that we might have some vaccine. Now we have multiple vaccines. We have over 1 billion doses, and we're moving towards 8 to 10 billion. So now we've solved the engineering or the science problem in the first part, and now we have to first accept that this was a miraculous result, but we need to do better, and if so, how? So then I put on my IP hat, and I think 2 fundamental statements, which not everyone I suppose will agree with. The first one is that the vaccine was developed in a record time because of the existence of the patent system, which underpins the biopharma market and is the reason why we have so many smart people, so much human capital to be able to rely on to solve these issues. And the second one is that the vaccine will reach most people because of, not in spite of, the IP system. This is because IP is not just an incentive system, it's a governance system. IP doesn't only block, it is important to facilitate openness and to regulate access. For example, open source is built on IP, on copyright. So waiving IP won't make innovation faster in the same way that turning off the lights, the street lights in a city won't make traffic faster. IP helps to manage the chaos of open innovation. And the third hat I'll put on is the political hat, which I tend to end up putting on a lot these days. I try to think, okay, why are we discussing waiving IP when the bottlenecks are in many other areas? What could be the reasons? And I have this kind of the three I's framework is ignorance, ideology, and interest. And certainly there's a lot of ignorance in this area. It's very complex, first of all. You know, Liya started us off by trying to clarify other things, which reading over the information that's out there, even recently, is not very clear. So for example, there's a headline, a patent waiver on COVID vaccines is right and fair by nature, a patent waiver. So we've established the fact that this isn't a patent waiver and that a patent waiver wouldn't necessarily help in many conditions. And did the US administration consult IP experts when it made its change? It seems to have made a change based on other thinking. When it comes to ideology, which of course is, we have the same issue. So if you're against patents or against TRIPS in general, then you're definitely behind the waiver no matter what. So it's good to think a little bit about, you know, if you don't believe in patents in this field and you don't believe in TRIPS at all, then it's not surprising that you're behind the waiver. So this of course makes it interesting for the US, which was more ideologically in another direction, switching in this regard. It's important to think, where are people coming from? The last one is interest. So what are the interests behind this? What is it that people are trying to do? If waiving IP is not going to be helpful, why are people talking about it? Is it virtue signaling? Is it developing countries finding they haven't handled the pandemic very well, looking to shift blame in some way? Is it free access to technology, strategic technology? What are these issues? So I think that this has to be looked at from a broader perspective. Now, with all that said, it's critical that when we solve this immediate crisis, that we need to put all the effort in to solve this so that everyone becomes vaccinated, that's for sure. We also need to discuss after that how to build better capabilities in developing countries in the long run. And I think the IP system will be important for that as well. Thanks.
Great, and it's a real pleasure to be here and batting cleanup. I hope I'm very much not like the mighty Casey, who's about to step up. I was awesome that both Sharon and Josh have invoked two issues that are very near and dear to my heart, John Locke and history, but I was not planning on talking about either of those, surprisingly, but maybe we can get into those issues in our further discussion. As a general framing, I would just like to point out or emphasize that that starting in the early 1980s with the extension of patent protections to biotech innovations through Diamond v. Chakrabarty, the extension of copyright and patent protections to high technology through the Copyright Software Protection Act of 1980 and Diamond v. Deere and many others, where the United States entered into for several decades a system of providing very reliable and effective IP protections for high tech innovations, both in the biopharma space and in the high tech industry. We've had the greatest, largest, most explosive growth in innovation and economics in our country and throughout the world that we've almost never seen before, on the foundation of these reliable and effective property rights. And so we've had the exact opposite of locking up and stifling of innovation. The connections have been that the property rights foundations have done what property rights do in all other areas of the economy and in life, and they've served as a launching pad for follow-on development, innovation, and growth and knowledge. And so that framing kind of leads into three 4 points that I'd like to make in my opening remarks very quickly. First is that contrary to Josh, and this is why we are having this great discussion, I don't think there's any evidence that patents or intellectual property rights more generally have served as a blockade or creation to either the development, the creation, development, distribution of vaccines or other drugs. In fact, I think the evidence is the exact opposite. Again, holding the context of the foundation that's been created through reliable and effective patent rights in biotech innovations over this past 30 or 40 years. Right. What that led to was an incredible amount of information sharing agreements that exist in and among companies. The investments, the billions of dollars investments that were necessary to create mRNA. Yes, there were small, teeny amounts, relatively speaking, of investments from the Department of Defense and others, but massive amounts of billions of dollars of private funding flowed into and made possible the mRNA platform. And in fact, this led to, massive licensing agreements and other commercial agreements during the COVID-19 pandemic. So you had BioNTech partnering with Pfizer because BioNTech had the innovation capital, the invention. Pfizer had the labor and capital necessary to help finish the development and distribution and get it out into the world. You have Novartis and Sanofi, who are actually making, through an agreement with BioNTech and Pfizer, doses of their vaccine for them. That's a commercial agreement. You have Merck producing on behalf of Johnson & Johnson, the Johnson & Johnson's vaccine. And even more significantly, you have AstraZeneca entering into a license deal last year with the Serum Institute of India, which hasn't been able to ramp up production because, again, the issue isn't patents, as I think Sharon and Josh and Bo have rightly identified, it's trade secrets and tech know-how. And so this is why we are at 100% vaccine manufacturing capacity at the moment. In fact, even more so because many facilities have been converted to vaccine manufacturing. And as Bo mentioned, there's the expectations are between 9 and 12 billion doses of vaccines, of the multiple vaccines we have, will be produced by the end of 2021, which all ensures that the COVID-19 pandemic, as horrible as it's been with the unfortunate deaths that have occurred, will not be a repeat of the 1918 Spanish flu pandemic, and where 50 million people died at a time when the world population was 15% of what it is today. So what then is the concern here? Well, the concern is that the real concern about is the message to innovators and people who spend decades developing incredible new technologies like the mRNA platform, which took several decades to develop from the 1990s up through the early 2010s. And that is, well, you can make these investments, you can engage in these productive labors, but if there is ultimately an emergency or a need of any sort, however it's defined, we are going to waive these productions, the rights that we've promised you, as any producers promise, whether they're a farmer who's spending a year of their life making crops, or someone, or a regular business person making billions of dollars investments in new commercial mechanisms and corporate forms to create new products as well. And this isn't mere hypothetical. The day that Ambassador Tai announced the support for the IP waiver at the WTO, AOC tweeted, "Great, let's do insulin next." Because there's a need for insulin, just as there's a need for COVID-19 vaccines and drugs. And Sharon is exactly right too in her opening remarks that the IP waiver will be limited to a particular time frame, or however they define the time frame of the pandemic. But we also know very well that trade secrets and tech know-how, once that cat is out of the bag, there's no taking it back. And and it's not like we're dealing with countries around the world who are known for respecting other people's IP rights or even their international agreements, like China and Russia. And so, and to the extent that we have to disclose this information to those countries, you raise serious concerns, both in the economic sense and in the national security sense, about what will be done with this technology when this pandemic is over. So, but I want to end on a positive note, because not just be here saying no, no, no. It's good to be positive, not just negative. And in fact, I'm going to suggest that there are actual proposals and positive steps that can be taken in light of what Bo has said. And these proposals are entirely consistent with the ideals of classical liberalism, which is that the problem isn't IP. And in fact, as described, I think very effectively, that the IP waiver won't even be voted on and implemented and approved and in time to have any real world significant impact in 2021 in 2022, by the time this pandemic is probably in our rearview mirror, both here in the developed world, but also in the developing world at that time. So what can we do actually to have an immediate real world impact in 2021? Well, remove the actual regulatory barriers that are preventing the distribution of vaccines and drugs and knowledge that need to be done, that have been invoked by the other panelists. The trade restrictions, the prohibitions on transfer of vaccines and drugs from country to country. The United States is sitting on a massive stockpile of AstraZeneca vaccines that it's not using because they don't have the same effectiveness as the J&J vaccine and the Moderna and Pfizer vaccines. Release that. President Biden has announced that he is going to start doing some releasing of some of the doses, but we need to remove all of these trade barriers of all the countries because there has been nationalism, as Josh just well described, but also removing some of the health restrictions and regulations that have been imposed as well. I mean, so the day after Ambassador Tai made her announcement supporting the IP waiver, the Pfizer CEO released an open letter where he described situations where he had reached out to leaders of developing countries very early on to say, we will send you our vaccine. And these developing countries said, the mRNA platform is radically new. We don't trust it. We are not going to approve it as a health policy matter. So under our healthcare regulations, their versions of the FDA, they prohibited the distribution of these vaccines in those countries because they were unsure of the legitimacy and the efficacy and the safety of this new medical technology. And so those are the real restrictions that are actually prohibiting the distribution of vaccines to developing world. And so I would say that we should be focusing on those issues and not talking about an IP waiver. So with that, I will end. I'm a little over. I apologize. I did strike out. I apologize, Liya. So I turn it over to our moderator and our other panelists to now explain all the ways in which I am wrong. Thank you.
All right. Thank you to all the panelists for those excellent opening remarks. Just a quick note to all of our attendees here. You can submit questions throughout. There is a Q&A box at the bottom of the screen, or you can also send it to me using the chat function as well. And I'm going to start with just a couple questions and also give a chance for some panelists to respond to some of these points that were raised. But then we'll open it up to your audience Q&A, to your audience questions. So feel free to start writing those up in the Q&A box. So first, Adam raised a point that basically the evidence that patent or IP in general, hasn't been holding up anything. There's zero evidence on that. And I wanted to give a chance to Josh or Sharon to be able to respond. Perhaps they are aware of evidence or perhaps they disagree on this point. So I'll turn it over to either Josh or Sharon.
Well, I mean, I can comment on what Josh said about the reluctance to license. Now, and I will wear my trade secret hat in doing this to refer to Bo's construction of the discussion. Here's the thing. Part of trade secret law and a great beneficial thing about trade secret law, it is designed to facilitate the sharing of information. And so what's happening, in my opinion, particularly given that article that Josh referred to, is that for some reason, despite the fact that the trade secrets and know-how could be shared with other companies and other countries without destroying trade secrecy, the trade secret rights and the assertion of trade secret rights with respect to information that may not even qualify for trade secret protection is not facilitating the sharing of that information. And that's the essential problem in my opinion. And that's the problem that we need to solve more broadly, because I think that the what I would call the over assertion of trade secret rights is leading to this unfortunate problem where information is not being shared as efficiently as it should be to facilitate further innovation and creativity. And so I'll let Josh comment on the same question.
So a couple of things. The first is that trade secrecy and trade secrets and know-how are intellectual property. Just start there. And if we disclose it through patent rights, then you don't have trade secrets. And the choice was to seek patent protection and trade secrets, which is a problem. But it really goes back to the question of how did we get the vaccines in the first place and how are we using the information? But by and large, the reasons that we don't have a patent problem in vaccines is first, as Adam correctly says, know-how and trade secrets have been the rate limiting step. And similarly, inputs such as, fill and finish bottles, such as chemicals for APIs, the active pharmaceutical ingredients, have been restricted by countries through nationalism. So I guess the question really comes down to, in my mind, we had 10 years of government funding to help develop mRNA technologies. No vaccines were generated until the miracle that Bo describes, that we were able to get it in 1 year with massive government funding and a promise of a guaranteed market, which doesn't usually happen. And then the consequence of that is that the people who did that development, building off of all of these in-licensed technologies, claim that the patent system is working just fine, when the converse is that we would have had these vaccines anyway without the patent system. The government clearly would have put the money in to generate the technologies once the pandemic had arose. So again, it's not that there isn't evidence of it. Pfizer is a good example. Why was Pfizer able to make its vaccine so quickly? Because it ignored getting authority to use Neon Green to run its clinical trials. Now, does that mean the patent system isn't a problem here? No, it means that one aspect, the use for clinical trials, has been recognized as needed to be outside of the patent system to allow us to generate these things quickly. And all the waiver is trying to do is to do that so you don't have to compulsory license all of these inputs, which takes a huge amount of time. And even if you did that, wouldn't be successful, because what you really need is the know-how. So what this demonstrates is that the system has failed. We were unbelievably lucky that we had 10 years of government investment covering the valley of death, where private investment didn't develop the mRNA vaccines, although Arbutus and Moderna had done some work, as did BioNTech, through government funding from the US and from Germany. But for that investment, these things wouldn't have happened. Same with the adenovirus vectors. And then we have a problem. The government throws massive amounts of money at it, and people say, oh, this is the patent system at work and it's successful. No, what it is it's nationalism at work. The consequence is that the post-colonial technologically advanced countries continue to have the know-how and trade secret knowledge to generate the needed things, and they refuse to share with the rest of the world. And the consequence is death and disease. Not to put too fine a point on it, this is post-colonial trade policy, not health policy. And it's really bad. And I'll stop there.
Thank you for that, Josh. Maybe a quick chance for either Adam or Bo to respond if you'd like. Otherwise, we'll move on to the next question.
And I mean, unless Bo wants to respond. I mean, I disagree with the factual claims and legal claims. As Josh and I are we are often on opposite sides of these debates, and I always love chatting with him. And I'm really delighted that Sharon has joined us for this one as well. I think the evidence is to the contrary, that actually especially in the mRNA context, that in fact, there was a great article in Stat from a couple months ago about how they couldn't get any grants. The woman who's now vice president at BioNTech, I have a hard time with her name, Dr. Karlashek, I believe it's pronounced. it was a long discussion about how she couldn't get grants because everyone thought she was crazy and insane. And this idea of using mRNA to develop vaccines and other drugs, and so they relied almost entirely on private investments to develop this. Now, what Josh is referring to is the Operation Warp Speed. Pfizer didn't take any money in the Operation Warp Speed. And also Operation Warp Speed did not go towards the actual creation of the vaccine itself. The vaccine was actually developed through the investments and developments, like I said, of Moderna and BioNTech through their private development. The Operation Warp Speed was just saying, well, we governments, by the way, we're not giving you a choice, biopharmaceutical industry. We governments are going to distribute this vaccine. You had no choice. So we are going to buy it from you. I mean, this is like saying, well, you want to sell drugs in France, they have a socialized healthcare system. You have to sell it to the government. Well, therefore, how, you're accepting the government's money. Well, they don't have a choice if they want to sell drugs in France and help cure patients. They have to go through the government, and they had the same quote choice unquote was offered to them in this context as well. And so the money was just pre-purchase agreements to help go through the final stages of approval at the FDA, or not approval, but emergency allowance of the vaccines. And in fact, I always like to point this out that, we actually had these vaccines in February of 2020, and the delay was not a medical or technology delay. It was an FDA regulatory delay. It was the efficacy testing that was done by the FDA through the fall of 2020 that delayed the distribution of these drugs. But I'm of the attitude that, hey, it's your body. If you'd wanted to have the vaccine early on and to be secure from this drug, then you should have been allowed to have taken it. And in fact, there are emergency allowances for those types of issues, and those should have been invoked as again, showing that the blockades weren't the IP rights. They were the regulatory blockades in the healthcare context and in the trade context, as Josh, I think, has rightly described. And we definitely agree on that point, that there's a lot of nationalism and blocking down and locking down of trading of information. So I think that the solution is to continue to foster and promote the very private ordering that has evolved out of the IP rights systems in the first place.
As I understand it, the research was just fully disclosed the critical research about mRNA was disclosed in a writing in 2005, and then subsequent developments related to that research was disclosed in further writings in 2007. So, yes, even though if factually some of that research was privately funded, there was an ethic, leading to the recent time period of sharing that information, which of course, that I think undercuts the traditional justification for intellectual property being the incentive theory. I actually think that IP is about providing incentives for commercialization, not invention. What is the major incentive for invention is problem solving or just intellectual curiosity. And I think that we don't pay enough attention to that because it happens all the time. And yes, the doctor who was responsible for this did not receive government grants. I would say that there is a gender component to that we need to acknowledge, and maybe we need to fix that going forward.
I want to move on to the next question, or I think
Bo, if you want a minute or two to add
just
your
a couple
comments.
of quick things. I think we have talk about, again, I try to see the big picture, and especially, when I think of trade secrets, I agree with you, Sharon. Trade secret legislation allows for you to transfer information. That's what it's designed to do, but I'm not sure that this is a legal issue. And my engineering brain says, well, this is a very few people that know how to do this. And if we take them from here and move them there, it's a zero-sum game. And they're going to be much more effective here than there, given that we want to solve this as quickly as possible. And then there's levels, right? The BOLAR creates openness in one level, but then don't have openness in another level. I think that's normal. There's some layers that you're going to have openness of information and some you're not. you might need incentives, might not need as much incentive to invent in some areas, but you need incentives to innovate. You might not, you might need government funding on this level, but you need to incentivize businesses on another level. It doesn't mean that just because the government was involved at one stage, that everything should be free after that. So we have these different layers, they all need to work together. And I think we have a system that's relatively useful for that as long as we apply it. And I definitely can agree that there's too much nationalism. So that we can all agree upon and try to solve that. Instead of hoarding 2.6 billion doses, I mean, that's going to go a long way. So.
Let me jump in and just make two comments in response to Bo, because I think we're really in much more agreement on this than we thought. The key question here is, do we need these patent rights to generate the amount of funds to scale up in the R&D, the clinical trials, and the manufacturing? And it seems to me that having $9 trillion in economic losses around the world and $7 trillion just in the US going into our economy over the last 2 years, you know, leaving aside that our children will be paying that off, I just don't see how, absent patent rights, the government in a pandemic would not have put in that funding. And, you know, similarly, the government had the authority, they didn't use it, but they had the authority to compel and take over Pfizer, Moderna, anybody to generate if this is really like wartime. And it should be viewed as wartime. The question, therefore, is and we're not going to be out of this pandemic anytime soon. And we know that all sorts of medical needs are going to come up in the future that have worldwide consequence. So the question is, should we change our system now in advance of all of that, as well as recognizing that it actually doesn't work very well, as has been demonstrated, in the context of routine innovation for medicine, such as the fact that we spend billions and billions of wasted dollars on clinical trials for third indication gastroenterology drugs, because that's where the profits can be made, and we're not spending the money on other things. That opportunity cost to society is massive, but because we rely on patents in the private markets to generate the investment, it goes toward where the profits can be made, not toward where social welfare can be enhanced. We need to change. The pandemic has lifted our eyes to say it isn't working.
I mean, one thing I could say is that I mean, the reason we had so many people capable of pulling this off was because there was a huge market created in the medical area to begin with. So we were able to pull from that. And I also tried to stress, I don't completely disagree with you that in a situation where there's a huge pandemic and governments are going to pre-buy everything, that the traditional incentive of the patent to get back your investment is completely the same as it is in a normal situation. But I believe that that IP allows things to be done orderly. It is what's needed to do open innovation in a good way. And I think that private ordering should be able to be handled on a voluntary basis this way. And I have a list of these as well. There's a lot, you know, 1 billion doses from AstraZeneca with Serum, 1 billion doses from COVAX to Serum Institute. I mean, Merck is making stuff for Johnson & Johnson, which no one could have even thought could be possible. People are collaborating and working together on this, but through the orderly nature of using IP and contracts just to create order, not necessarily just for pure return on investment.
So let me just say one last thing, and then I think I've really exhausted all of the things that I want.
Liya she has to take control.
Yeah, and that is that, you know, it's not just pharma here, it's the rich governments, because what we've done is we've jumped the queue to pre-purchase the stock of the vaccines that we've generally funded, just like Europe did, and now India has. And the consequence of not putting it into a worldwide system of shared pooling information is that people around the world who are most at risk don't get the vaccines first. We're holding on to it, even though we've pledged excess supplies to other countries, to inoculate down to very low risk levels in our own country. And the consequence isn't just to permit death around the world, it's to increase death around the world.
I think we might find agreement on these issues.
Right, and
Yeah.
we need a worldwide system of development and control, and that's not going to come out of a private market system. That has to come from governments agreeing to pool the technologies and share them equitably around the world. This is a wake-up call before the next pandemic hits and people start jumping to get their own, and the rest of the world dies even more death than we are seeing now. It's we just have to change.
Yeah, let me add something, because Bo, I agree with you that one of the benefits of intellectual property laws is to make things more orderly. My concern is we're not paying attention to what I call the chipping away at disclosure principles under IP law that is leading to an over-assertion and a lockdown of information. And if you just make a list of all the laws that have been changed in the last 30 years that chip away at the sharing of information, it's very frightening. I mean, you start with US copyright law, eliminated the publication registration requirement and allows for registration with, where you can hide certain information. The US patent law enablement jurisprudence and the changes to the best mode requirement. You have the AIIA, which is attempting to narrow the definition of prior art, not to include inventor commercialized trade secrets and information known by third parties. The restrictions on working requirement that Josh mentioned, problems with the Bayh-Dole Act, which I don't think requires sufficient amount of disclosure, both in the front end and in the back end. The data exclusivity provisions of the TRIPS agreement, and also of all the free trade agreements that the United States entered into.
But this is what I find interesting, Sharon, because I sit in a lot of other meetings, and people are just as unhappy with the Supreme Court weakening the patent system, and just the opposite of what you're saying. So it's interesting how we can have one system and have people completely see it from a completely different direction.
Well, I mean, that has to do with patentable subject matter. What I'm referring to is the changes to the definition of prior art. But, so anyway, I think the combination of this and also the international trade secret harmonization efforts have tightened up the flow of information. And to be clear, I'm in favor of trade secret protection. The problem is that companies and the general public don't understand the limited scope of trade secret protection. And so what gets caught up in the periphery is this type of information. General skill and knowledge is one term that's used in trade secret that used to flow, that apprentices working at a company back in the old day actually learned how to, use the technology that their boss taught them, and could take them to other jobs. And that's part of our law. We always thought that was an important, that kind of a leakage, I like to call it leakage of information, was important in our society. In fact, the leakage of information is what saved state trade secret law from being preempted by US patent law. If it weren't for the leakage, it would have been held to be interfere with the US patent law. And so I think we need to accept and understand the benefits of the leakage of that kind of know-how and general knowledge more so than we are currently.
So I want to step in and just comment on something generally, which is that, so there's a lot of what economists call the nirvana fallacy here, a very high generalization. And also I want to push back on this idea that IP locks up. This is kind of a classic academic framing, and it's the conventional wisdom in academia and among a lot of scholars that, it's the incentive to invent, and then you monopolize, and then the monopolize locks up and clamps down, and so there's a social net loss, and therefore you need to balance those between the loss of the monopoly versus the incentive to invent. And that's just kind of the false perspective. Yes, that's the attitude you have if you actually have a monopoly system, if you actually have, go back to what existed in England when these were personal privilege monopoly grants that closed down commercialization and industry. So now what the United States adopted, we took a property rights approach, just like any other property rights. And patents no more lock up something than a farmer's property interest in their farm locks up something. The farmer produces crops, engages in commercial exchanges with distributors, wholesalers, retailers. You go to Giant to buy here in DC to buy your produce. You don't go to the farmer. There's a massive value chain that's created through commercial exchanges and developments through property rights. And patents have done the exact same thing. It's what I was hinting at when I said we took the lead among the world in extending patent protections to biotech innovations, high-tech innovations like software. And guess what? Because of that, the biotech revolution and the high-tech revolution happened in the United States. And it didn't, and what I mean by that is it's not just that the inventions happened here. The industry developed here. The entire sector developed here because new corporate forms, licensing like Microsoft through licensing of Windows and the licensing agreements that were entered into, massive trade sharing agreements and other commercial arrangements like you have between BioNTech and Pfizer. And as I described earlier, created a foundation for the distribution of goods and services that were unheralded and unknown of before. And, so yes, we could go the top down, we need a world government, UN controlling everything and distributing the vaccines. And I think that will be as successful as we have seen with all other times that the government has stepped in and has taken over and has dictated under what conditions and in terms. And in fact, we've had the vaccine rollout in the United States was largely complained of and stymied for months because of exactly the government stepping in and locking it down, as opposed to having the companies just distribute it the way that they would have normally distributed it through market processes. So you can say, oh, there's a problem here, everything's locked down, as compared to what, and then you have to always consider that you have the same institutional problems and costs that you were invoking with the government and with public institutions like the UN, as you are complaining about with as one might complain about with corporations, but then also recognize that the actual evidence of the market developments through patents and through copyrights and other types of intellectual property rights, including trade secrets, are that you've actually had massive innovation in the past 30 years, not lockdown. We have incredible, there are cancers and other conditions that are now no longer death sentences. There are manageable day-to-day conditions that were created through the very system that everyone is decrying now as a failure and as locking down stuff and preventing the development of treatments and information. And it's just, I don't know. I look at the evolution of the market processes and the evolution of our innovation economy in the biotech space and in the high tech space. And it's been explosive growth, incredible, massive new innovation from smartphones, which have thousands of patents covering them, to new drugs and vaccines. So I just see the exact opposite. And I want to push back. And that's because patents aren't just about incentivizing invention. Sharon is right. Patents and other IP rights are about facilitating commercialization, but not because they force disclosure. Is that they provide a foundation for people to engage in private ordering through contract and other agreements, like they do in all other areas of the economy with all their types of property rights, to create and facilitate value chains that actually produce new products and services that have driven our innovation economy for 200 years.
I think,
thank you. I think
okay.
I'm going to jump in here because I did promise our audience that we would get to Q&A. And so we have a question, we have hands up. So I'm going to jump to audience questions right now. So the first one, it was written to us in the chat by Justin, and I'm going to read it right now, or if Justin is on and wants to jump in and ask it in person, I think we can unmute him. But so Justin asks, how can a reasonable line be drawn between waiving all COVID related IP rights on the grounds that, quote, the world is in pressing need on the one hand, and waiving all IP rights for cutting edge drugs on the grounds that patients are in pressing need on the other hand. So either patents for inventors are a net positive for society that should be sustained and enforced, or they are not. So that's kind of the debate that we're having right now at the end of the day. So this COVID waiver seems like the first step in a larger government initiative towards ultimately eliminating drug patent rights altogether, whether explicitly by statute or implicitly through price fixing measures. Are my concerns overblown?
I guess I can take that one. So this relates to what Adam was just talking about, which is we don't have, unless he's got a TARDIS, alternative universes to see if we actually would have had more innovation and more development than Adam is touting as a good result. But we do have some historical examples. World War II, government directed industry, working with it, but directing the rate and types of innovation, and that seemed to work out pretty well. But more importantly, again, back to Adam, this didn't come with the Chakrabarty decision. It actually came with the biotech revolution came with the 1959 UN Declaration on the Permanent Sovereignty over Natural Resources, which also made this not a common heritage question for the development of biotechnology, which would have benefited all, and then we would have had the alternative universe, but rather it made it a nationalist trade issue. And yeah, we won that race, but we were also, had our head start because of colonialism in that race. Now, going to the question that Justin posed, it seems to me that what the pandemic has done is it's demonstrated that the system doesn't work very well. We already knew it didn't work very well for neglected diseases and access to medicine in terms of pricing around the world, but it also doesn't work very well even for the goods and services that we actually need in the US to deal with a pandemic. You think about all of the different technologies, not just, again, vaccines, but therapeutics, diagnostics, medical devices, et cetera. And we have faced all sorts of shortages. Now, some of the shortages are supply chain questions, but some of them also were intellectual property rights. So, the question is, how do we get past this continuing focus on intellectual property? And if that means that we now realize that we shouldn't be doing our drug development this way and the government should take over clinical trials, that's really very well invested money for our taxpayers.
Thank you, Josh, for that response. And I think it gets to the heart of what this debate is really about, is whether the current intellectual property system is interfering with development or it's encouraging, as seen through the discussion of your points. So now we have a question from Charles. Charles, I'm gonna unmute you and allow you to talk. So go ahead.
Oh, hi. Actually, I incidentally must have pressed to raise my hand, but thanks for giving me the platform now that I'm speaking anyway. One thing which I was thinking, but I didn't want to necessarily raise it as a question, but when I hear Josh speaking and giving the World War II example, one thing which I thought was, I give it to you that governmental organized innovation works well when it's mission oriented. I think when you know exactly where you want to land. Say your goal is we want to destroy the Japanese and we want to throw an atomic bomb. I think that's the kind of task that you can entrust government with, because you know who you need to invent what. I think the case turns a little bit more in favor of IP when you're talking about a process of innovation where it's totally unclear where you're heading to, when you're talking about a discovery process, which means you want to invent new things, but you have no idea on what precisely it is that people need, what precisely it is that entrepreneurs will come up with. And then I think it's much more it's harder when you don't have this mission-oriented perspective. Then I think you will need to rely more on IP. So what do you think of that, Josh?
I have thoughts which are that that's precisely the situation where we need government funded research. That's precisely what happened in the case of mRNA. there, until they could figure out a way that it could lead to a vaccine in this case. It was just an effort of curiosity that had to be funded through our universities, and I know Adam mentioned that there was some private funding, and I get that. But the point is, I think a lot of the discovery type research we do is not driven by IP. It's driven by intellectual curiosity and wanting to make life better and solve a problem.
Yeah, I mean, I agree with Sharon at a high level generality. Yes, that people are curiosity driven, and people invented even before patent systems, and there's lots of alternative mechanisms for incentivizing people to invent if you want to invent. But I think Charles' question's got at a really good point, which is that there's a difference between invention and innovation. And the question of how you produce and develop innovation is an important foundational and fundamental question. And I just want to push back again on the fact that mRNA, that it was almost entirely privately driven and privately invested in. And it wasn't just a matter of curiosity. They were working on vaccines and other drugs to develop it. And they had, through the private investments, they had developed the technological platform and the various commercial and information sharing agreements that they had entered into with lots of other companies, as evidenced by some of the links in Josh's charts that existed before the COVID-19 pandemic. And I always, and when I mentioned that we had the vaccine in February, actually we had the vaccine in January. I mean that the vaccine was turned over to the FDA in February for testing. The moment that the Chinese released the genome of the COVID-19 virus in January, the story is often told that Moderna created its vaccine in 2 days. Because they had this foundation of this existing technological know-how and commercial investments. BioNTech beat them, but BioNTech actually created their vaccine in 2 hours. And I mean, this is incredible, in technology, which is, by the way, again, another re-emphasizes the point I made earlier about the concern about releasing kind of the tech know-how and trade secrets about this, because you're not going to be able to restrict it just to the COVID-19. So it doesn't matter if the IP waiver says this is limited only 3 years, because once that tech know-how is out, it's out. And it's going to go to, and it has to go to countries that are not necessarily friendly to us, like China and Russia, which are competitors, both economic and militarily, and are not known for respecting even their own citizens' rights. Ask the Uyghurs how they feel about the Chinese government. And so this is a technology that can be used to develop more drugs, but it also can be a technology that can be used to develop weapons, biological weapons. And I mean, and these are things that we need to think about and need to become part of the broader discussion here, that this is not about locking down. This is about, ensuring, effective and proper, actually enhancing social welfare through basic principles of property rights, contract rights, and liberty rights. This is why, the founders, didn't think of its, individual rights uber alles, regardless of what happens. They actually firmly believe that protecting individual rights promotes social welfare, leads to societal happiness. He said this in the Declaration of Independence, and even Madison says this. Madison was not a utilitarian. So when he said in the Federalist 43 about the patent and copyright clause that patents and copyrights are the place where individual interest and public benefit go hand in hand, he was invoking a general principle that they viewed about property rights as such.
So I don't think Adam meant to, but he certainly made that this is about techno-nationalism and trade advantage. And we just shouldn't go there as a world.
I think one thing that we can agree upon, if we go to the future, I still think that the companies and the collaborations that are in place, I mean, the Indians have their own vaccine. They can ramp that up if they want. AstraZeneca has given 1 billion doses to do. I mean, they can ramp that up, sell it to whoever. So the Chinese have given out the vaccine. The Russians have given out the vaccine. So there's lots of vaccines that are just possible for people to infinitely to create. I mean, law doesn't stop you from doing something. It gives you a consequence if you do it.
Law didn't stop Pfizer or BioNTech or Moderna from refusing to sell its vaccines to the US, but selling it directly to COVAX to share it on a prioritized basis through the World Health Organization around the world. But we know that they weren't going to do it because of nationalism. And
But Josh, that's contrary to explicitly what the Pfizer CEO said. He
Yeah.
said he called up leaders of developing countries and offered them the vaccine for free, and they turned him down.
yeah, that's
I mean,
also
are you saying
contrary,
I guess
contrary
you're
to,
just saying he's
contrary to
lying.
what Albert Bourla said to COVAX. The idea that they're going to take our rights and that we're going to give it to COVAX is
But the one thing, so you know, I put on the engineering hat again. My engineering hat is always like, okay, what, how do we get this out to everybody? At this stage, I don't think people care where it's made, how it's made, just as long as they get it as quickly as possible.
But they actually do care, because the Chinese vaccine we know is much less effective. Hard to know about the Russian.
Except for maybe ineffective vaccines, of course. But
Well, but this is why we need to scale up manufacturing so dramatically now,
Right.
precisely because it's not just about saving lives overseas. It's also about not generating variants that are going to come back to kill us. So
Sure,
the
no, I think
nationalism-
but I think everyone agrees on that. And of course, there are
Yes, but they
vaccines.
don't agree on how to ramp up the manufacturing and whether to force the know-how transfers to make this.
But one thing
in
to
the
think about
places
here,
that will happen.
sure, but one thing to think about, and I saw the statistic, which kind of shows the whole problem, is that 99% of all vaccines are imported into Africa. And most of those vaccines, I assume, have no IP issues associated with them. These are just vaccines that have been around a long time. So they haven't built any capacity
Right.
to manage vaccines at all in Africa. And of course, now they say that by 2040, they're going to change it in that. But these kind of fundamental structural problems that require innovation, these are the things, instead of relying on this situation to pop up like this, if there were more people who could handle this, the situation would be resolved. Because even though maybe some companies like Pfizer, who's offered to sell it themselves to people at cost, there's other actors like AstraZeneca and COVAX, other people that have offered to let other people make it. We would need more people with more capabilities. They haven't done that. They haven't built that up. And so it's a failure systemically on that level. I can agree with you.
I totally agree with you. But again, even in regard to the mRNA and adenovirus vaccine vectors that were approved, I started my discussion precisely with quotes from a news article explaining all of the generic manufacturers who said, let us make that vaccine. And Big Pharma said no, just said no, we won't do it, whether it was for safety reasons or for other reasons. But it's not like these companies weren't capable of doing it and weren't capable of doing it safely if that know-how had been transferred, or even without it for the adenovirus vectors.
Right, but I think that if that know-how had been transferred, the engineering brain picks up again, because I think if Pfizer transferred their knowledge to another part of Pfizer, it would take 2 years. I mean, this knowledge, just you say like knowledge transfer, like it's a signing an agreement. Yeah, this is a very complicated thing.
Yeah, I mean, related to that, one of my big fears is, and so all of those that know me and my scholarship, the initial focus of my scholarship was on basically just educating everybody about trade secret law and the particularities of it and the limitations of it. Now my scholarship is about information access and knowledge diffusion. And my fear is that we live in a society, particularly the developed world, where there's a fear of kind of informal knowledge transfer. And that really upsets me, because that in a society, in a world where we value, education and innovation and creativity, and we shouldn't be fearful of the more informal knowledge transfers that come when, an employee goes to work for somebody and learns something and can take it to their next job. And I think that's a problem, and we should be thinking about that. And so one of the questions I have is, to what extent is this, reluctance to license this technology to companies that are willing to enter into a confidentiality agreement? This fear of kind of losing that peripheral information, I think that's a big problem.
And with
I just
9
wanna-
economic losses, the world could easily compensate for the entire destruction of any trade secret.
So, but I just want to quickly make 2 quick points and then turn it back over to Liya, which is that Bo makes a really good point, which is that this is not an IP issue. This is an infrastructure issue. This is a distribution issue. No, over 90% of the essential medicines identified by the World Health Organization are off patent. There's nothing preventing anyone in the world from making them, distributing them. So what's stopping it? It's because in the developing world, they don't have the infrastructure or the capability or the means to do so. And that's not on Moderna or any IP owners' shoulders. That's on their government shoulders and their people's shoulders to make those types of investments themselves and to develop it out. And in fact, there's the economic evidence has shown positive a causal correlation between positive trade flows and developing actually IP protections in those countries. So for those countries to actually adopt IP protections leads to greater foreign investment, greater investment in the actual infrastructure they need to distribute these types of things. But again, that's not an IP. It's not an IP issue under our country's laws or even at the WTO level.
All right, so great lively discussion, but let's move on to other questions. So Richard.
We're going to agree to moderate again, are you, Liya? It's tough. It's a tough crowd
No, not with the 4 of you.
here.
So Richard, you had a question. Do you want to go ahead and unmute yourself and ask your question?
Yeah, I do. I mean, I think that there's been a real mistake in this discussion to attribute to vaccines wondrous powers and to ignore the effect of medicines, most of which are generic on this subject. I don't know how many of you actually have followed this, but there are now a fair number of reports which suggest that the rate of damages, injuries, and deaths from these vaccines is higher than one had expected, which is something I believed was going to be the case, simply because there's a high variation in the subject possibility. And I'm a great believer in joint causation on these things, which is you have a background condition and you inject one of these vaccines, the 2 things together can do it. Very few people will have the joint conditions, but when they do it, it's likely to happen. So everybody knows if you've taken the 2nd dose of Moderna, it's a real jolt. And if you have somebody who has platelets or something like that, which is off, it can really do a great damage. On the other hand, there are the medicines. Ivermectin and HCQ. What I find so extraordinary is that the standard profile, these are both generic drugs, both have been used in a wide number of circumstances successfully. So the effectiveness risk is far lower than it is with respect to the vaccines because these things have been tested. These are extremely cheap products which can be made for pennies as compared to something like remdesivir, which Mr. Fauci has advocated when he's blocked the sale of this. When you look at places like India, their use has been tremendously effective. And so the question then is, what institutional situations has blocked these drugs? And it turns out, as best I can tell, it's politics in the United States. I think I'm going to be kind of uncontroversial about this. I think the single most ignorant man in the United States on medical issues is Anthony Fauci. He's just been consistently wrong on everything and overconfident to boot. And so why is it that we do this particular thing when in fact there is a very powerful alternative, which is to simply get these things into wider circulation? So I disagree with Josh and with Sharon on the following proposition. When there's a defect, always have a government solution. I think the correct situation is when you have a defect, try to remove the government obstacle. And so I'm curious to get everybody's reaction on this as to why it is that the pills don't use. And this is the key point. You only take a medicine if you're sick. You take a vaccine if you're not sick. So you can now reduce the population that's going to get this stuff by 90 or 95%, which means that things are going to be much better. And if you can do this, then it seems to me that it changes the calculus on your willingness to give the vaccine. And I think that there's just been a complete failure of this. And I don't think it's attributable to the intellectual property system. I think it tends to be attributable to lots of other things. And I see somebody has a note about off-label drugs use that can ask the question. But at least I just wanted to make that little speech. And I'm just curious what everybody's reaction to it is.
So
All right, we're going to have Josh go first, and we're going to keep it to under 45 seconds or a minute. That's fine, but we're running out of time. I want to get to another question and then have each of you say like a closing statement as well. So let's keep it
I largely agree with Richard, particularly about the politics and about Anthony Fauci, and that therapeutics are critically important. It's not clear that ivermectin and some of the others, including remdesivir, actually have as much therapeutic efficacy.
Oh,
particularly-
remdesivir is worthless.
Right, as people say, but molnupiravir, which Merck is developing, may have substantial efficacy if it gets approved. The whole point here, to tie it back to the waiver, which is where we started, is you already have compulsory licensing under Article 31, which says that anybody in the world, once that patent is disclosed, can make it, precisely because you don't have to compel know-how transfers, and presumably the input chemicals and input processes aren't going to be patented and don't need to be licensed, but the product itself eventually will be. By the way, there are no actual patents on the vaccines, and there won't be patents on these products for a while, at least for the ones that are not off patent already, for the new stuff. So what is this all about? Countries can already compulsory license once these things are disclosed and approved. It's about avoiding trade retaliation when they do so. That's what the waiver does. It doesn't make anything change in the countries, except in those rare countries that are both civil law jurisdictions and treat the waiver as both self-executing and as superseding their own laws. Consequently, I totally agree with Richard, but the one place I'll disagree with him is therapeutics don't reduce viral replication and therefore won't get rid of the pandemic. All they'll do is reduce death. I'm all in favor of reducing death, but we should also try to reduce the pandemic and the number of people, precisely because long COVID is also an issue, and we'll have lots more death.
Yeah,
over
but we
time.
made huge numbers of mistakes on that by the quarantine as opposed to allowing asymptomatic transfer. I mean, this is just one blunder after another, and it's all done by experts. And
Agreed.
and so, I mean, one has to genuinely fear these people because the government monopoly is something you cannot displace.
All right.
Right.
And then do either Adam or Bo want to say something on this point, one or the other?
No, they agree.
Okay. All right, good. So let's move on to the next question then. Mario asks, why doesn't the US and other developed countries simply spend the money to buy the vaccines from appropriate manufacturers for delivery around the world? After all, money is free.
Again, I'll take that one. They did, but they did it by jumping the queue and using it for their own populations to go down to the lowest levels of risk rather than doing it around the world according to prioritized access and prioritized risks that would have reduced overall death, overall replication, and overall risk of generating variants. But just tell me, what country, if it didn't actually have citizens demanding that they follow the golden rule, would actually say, we're going to protect other people in advance of us, even though that is the right thing to do, both as a matter of reducing the disease and as a matter of morality? You know, it's a hard political choice, going back to Richard's point, but it's the right thing to do.
Yeah, I mean, just very quickly, I mean, they could have done this. They you know, any country could have done this, but they imposed, as Josh has described and as others, and we've talked about already, massive amounts of trade restrictions and other embargoes on the transfer of vaccines. And so, in fact, even to release these vaccines requires a special executive order, as Biden keeps doing in these little piecemeal bits, like, oh, well, 5 million doses will go now and done. I mean, they should just remove all of these unnecessary regulatory restrictions that they've imposed on the free distribution of and or just commercial distribution of these drugs.
Don't leave pharma out, because they didn't have to enter into the nationalist contracts. They could have contracted all of their supply with the WHO COVAX facility and forced the governments to seize their property. That's what should have been done, and it should have then been transparently politically obvious that this was about nationalism. Instead, they're betting to try to keep regulatory favor. It's just bad politics all the way around, private sector and public.
All right.
Yeah, I mean,
Well,
I wish we could coordinate on a global level
Yeah,
things like
yeah.
this, and I think we do relatively. And
Yeah.
again, going back to the first thing I said, I think we've come very far very quickly. If we would have told people, would you like to have this situation now, back in the beginning, I think people would have taken it. And it doesn't mean that it's perfect, but no situation is perfect. There's a lot of these, you know, things could be better, nirvana policy statements. Well, we don't know. It could be worse, actually, too. We always think it could be better. We never think it could be worse. Oh, it can be worse. And so, and even India is blocking export. So nationalism is, is very close to human nature, obviously, because we see it very quickly rearing its head.
Okay.
Oh,
All right.
Colonial nationalism.
All right. Well, I wanted to give the panelists each a minute closing remarks, but given how lively the discussion has been during this time, I'm actually going to go ahead and close now because it is at time. And so thank you to all the participants today. I think one thing that this debate kind of highlights is that differences in opinion on whether the IP waiver is good or bad actually stems down to more fundamental differences about questions of our patents and our IP governance interfering with development and innovation or enhancing it. Also differences on whether it's IP and patents that are holding up anything, or whether it's things like an infrastructure and manufacturing. So it has been quite an interesting and lively debate. I hope everyone got something out of it. And again, this event is hosted by the Classical Liberal Institute. And if you are interested in learning more or getting involved with the Classical Liberal Institute, you can chat with me or visit our website at www.classicallibeраlinstitute.org. And there you can sign up for our newsletter to be involved with us and to know more about future events like this. So thank you all for your time, and thank you to the panelists for the lively discussion.